6. And law school offers what? Order to make your case class go. It is time to go back to where we began, and to take bearings once again on what it is all about. I propose to take observations with you along 3 different lines. First, what is the orientation of the school with regard to the profession? What does it offer that you need? Why does it offer some things and not others? What do you need for your practice which it does not offer? To which the answer is almost everything you will need for your practice. And as inescapable, I shall have something to say on how to stay in the school. Tomorrow, a second line of observation. What of the law in reference to our civilization? What is it worth? How did it get that way? What does it add? In part derived from the first 2, there is a third line worth pursuing as we close these lectures. What are the possibilities in studying law? To what end? What is there in the study worth the having? Now to the school, and first, to the curriculum. What is its aim? We have already seen that it has 2 aims at least. One is to equip you for the practice, the other to equip you for itself. Let me begin with equipping you for practice. And there, I suppose, the first thing which occurs to you, as the first which would normally occur to any man, is that you need to learn the law, that you need information, knowledge, that you become the repository of the rules. I am Sir Oracle, and when I ope my mouth let no dog bark. Would, gentlemen, that we could make you so. But between us and the making stretches looms a bulk of learning which 3 years can never compass, which, I think fair to say, no lifetime is enough to compass. Any system of law bulks large enough. The law of a high civilization bulks out of all understanding. Our own law is the regulation of the clashes of interest in a society so complex we gasp before it. Even then, there might be some hope of learning much of it, for rules are all abstract. Even if one has to wrestle with a dozen cases for each rule to see its meaning, the abstraction reduces the ground to be covered. The rules, laid end to end, no longer stretch so many miles. And so, in France or Germany, where great portions of the rules have been reduced to systematic codes, law study gallops desperately across these stretches, endeavoring to heal the aspirant on all the law. The task is made relatively easy by the fact that the codes are cleanly thought out, well-ordered books, neatly enough phrased in the main, and wide in their scope. The task is made relatively easy also by there being in substance but a single system of law for Germany, a single system for France. One legislature, one Supreme Court. And despite this, the instructors throw up their hands and pant at the impossibility of what they try. Despite this, the worry grows at the hopeless over-abstraction of what they teach. So much so that in Germany, for instance, a sort of legal internship 3 years in length follows upon the 3 or 4 years academic study before the young man is allowed to take up practice. We have 3 years, save in a few states, no internship at all, and even there it runs both loose and short. What is more and worse from this angle, we have no code. Statutes we have, mostly irregular heaps of what happens to have seemed worth legislating on. They are no ordered body, still less are they an attempt to cover the whole of law complete. And save for the statutes, our law is found in cases. Hard therefore to find, hard to dig out, difficult to phrase, unwieldy, cumbersome. Nor is there one legislature, one Supreme Court, but 51, each speaking its own last word and adding its pronouncements to the mass. Go down to the shelves and count the shelf feet of repositories of our law. Ask the librarian how many shelf feet per year are added. Know the nature of our system of multiple jurisdictions, the accidental constellation of our statutes, the inductive concrete method of our case materials. These make the learning of our law entire, as information hopeless. Then what to do? We can pick out some fields of information which look peculiarly useful. Some we feel that every lawyer needs to know, as such. These are very few indeed. I personally should count nothing in but some procedure and some evidence. Other bodies of knowledge we feel sure are, in our system, working and thinking tools of such basic character that one must have some familiarity with them to think like a lawyer, to size up a situation, to orient himself among the branches of the law. Also, lawyers will need some part of these bodies of information directly in their practice. So, some contracts, some torts, some trusts, some corporations, some property, some equity. From here on, the question of information becomes more incidental. The chances of any particular student being able to use directly the amount or anything like the amount of information he acquires even in these courses is very slight. The information becomes rather a vehicle for study. Without the information, no understanding. Therefore, the information must be insisted on. But it does not, from the angle of professional use, have peculiar value in itself. One could make 20 courses which we have not, and no school has, and substitute them for 20 that we give, and no great difference would be made in grand utility. Again, go to the books, with your school catalog in hand. Get down the table of the major articles in Corpus Juris, and compare them with the catalog. Moreover, any live instructor could build several courses, good courses too and useful, on material which Corpus Juris has not yet become aware of, or could build 3 out of any one we give, so that we turn on the side of information, after exhausting the little odds and ends most men will surely need, to doing with you what your college instructors attempted, equipping you to find what you want when you know what it is, and to knowing what it will be. And on both matters, the job we do is lamentable. It is hardly an exaggeration to say that we let the job alone. Note then your first extracurricular task, to find out how to know what you want in the way of law, to find out how to get it when you want it. That is not of peculiar importance this first year. It is your main job next year, and another main job next year and the year after will be filling in information, reading for yourselves. Information which you need because you are you, not because you are a member of a class. Information that has to do with your prospective practice or your interest or the deficiencies in your present stock in trade. Information, therefore, which cannot be poured on just and unjust alike as is the rain, but must be cut and fitted to your needs. In 3 matters, particularly. The cases of the state in which you intend to practice. It is not enough to know a prevailing American view. If the case is up in Chicago, you need to know the law of Illinois. It may be peculiar to itself. It is never too early to start in on your notes and independent reading in this regard. Not that the law of your own state is the only thing that counts, even where it is settled. I have been wasting breath if you have not come to see that method is everywhere alike, and that you cannot learn method except by grubbing with the same details which occupied the court whose method you are studying. Moreover, transactions make no bones about crossing state borders, nor does the mail. You need an extensive awareness of what law lies beyond, and holes in your own settled law will be filled with an eye on what lies beyond. But that is no reason for not accumulating a growing body of clean-cut notes on your own local law, which leads to the second point. The text of your local statutes. It helps amazingly little in fighting a case to know the fine old rules of the common law, if the local legislature has been busy making that fine rule over. What subjects has your state got statutes on? And what is in them? Then back to the cases. What have the courts done with them? Little enough you will find of this in your curricular classes. Finally, there are fields of law you will not have time to take courses in. Indeed, there are fields in which no courses will be offered. Now there you have a just grievance. You are Americans. And Americans know, as of right, that education comes in packages, like perfume. Content is immaterial. The package must attract. When you buy it, you have it. No course, no education. If no instructor drives, let there be darkness. You have a grievance. But your grievance will not help you. There is no justice, social or legal, in the matter. There are, of course, books. An interesting thought. Might it be part of one's legal education to peruse a book? Might it be part of a legal education, even to accumulate some books? I wonder sometimes what students think a legal education looked like before there was a law school. This you can tie to. If you are after information, it can be had from books at something like 1/10 the cost in time per cubic inch that you will pay out in a case course. And this too you can tie to. No so-called course has ever covered a subject on the information side. The first job in course or case book building is to decide what parts of the subject to leave out, to never mention. It is important that you realize this. Even the courses, I repeat, do not begin to cover the respective fields which go by the same names. From which it follows first, that a whole view of a subject comes always better from a book than from a course. And second, that there is no virtue in an instructor's covering the whole case book. Much more important things have commonly been left out of the case book by the editor than are left in it for the instructor to leave out. And it follows third, that even if you have bartered your soul to the package theory of education, you will be in trouble. Your pounds are 9 ounces. Your dozens run from 7 down to 3. So that on the side of getting the rules, to sum up, the answer is: to cover the ground is impossible, but half or so of the curriculum touches material, which has much value for most lawyers. We do not purport to teach you the rules you need to know. We run on the theory that we are a full-time school. That theory means that students are to get not courses, but an education, and that they are to put in 50 hours a week in getting it. On the other hand, we labor diligently, and not without skill, at getting you to handle cases when you find them. This is the matter of case law technique. I shall not repeat what I have said about it. I shall note only that there again we do not teach you learn. If you learn, then we may be said to teach. But our part is like the sowing of the wheat. It must be sown, it must be fertile, but the sowing is soon done. Time, soil, and weather make the crop. Moreover, you will notice that any wide synthesis of the subject matter of a case class is left to you. Piecewise, we help. As to any whole, our wiser members still leave you largely to yourselves. A second reason for review. The first daily and weekly review is to build firm footing under technical work. The second reason is the reason for the grand review: to see the subject whole, to gain perspective. In a word, to get stuff so filed in your head that you can quickly find your way about, and also have a guide on whither to drive for your whole training. One other piece of technique we start you on: the argument from cases. But here again, class training reaches only to argument on the narrowest of points. Argument on the grand scale that is left to you. And see what goes into it. First, the analysis of the situation, the picking of the pertinent questions, the framing of the questions to be presented. Here is a double job of synthesis. You begin by putting together law that bears on the question. When Hines or Harris takes cigar in hand to stab the aces in his narrative to you, his case does not come labeled, "I am a case in torts." It is more likely that the situation involves elements of torts, of trial practice, of corporations which you may indeed have had, but had each one separately, and also some phase of public regulations which you have hardly heard of. All to be sorted out, all to be seen, all to be put together. Here then goes along with analysis a new synthesis of law from different fields around the situation. Seeing possibilities, reading to discover other possibilities, finding the case or statutes and discovering their bearing, seeing how they fit together and affect each other, weighing their relative importance. A next job of effective synthesis. Framing the argument, giving it a beginning and a middle and an end, making the middle grow out of the beginning, and the end an inescapable development of both. Meditating on the tactics of persuasion, which point to center on, which facts to stress. And shall you put the strong point first to make a strong impression, or put it last to leave a strong impression, or discard all but the crowning point and gamble on the clarity and force of concentration? Such matters are the meat of our profession, but have as yet no place in class. You can begin a training on these lines in the extracurricular moot court, the play court before which students argue pretended cases. And moot court work will head you too into the library, and into the first attack on finding law. Moot court work will bring you into quick contact with a group, and in groups of students lies your hope of education. I pause an exposition to exhort. What I am trying to write in fire on the wall is that the task before you is immense, is overwhelming. and that the official courses of the school are not enough to compass it. Tekel. Thou art weighed in the balance and found wanting. To do the work is not to do the classes. Rather must you immerse yourself for all your hours in the law. Eat law, talk law, think law, drink law, babble of law and judgments in your sleep. Pickle yourselves in law, it is your only hope. And to do this, you need more than your classes and your case books and yourselves. You need your fellows. You need your neighbor on the right. Grapple him to thy soul with hooks of steel, with boarding hooks, if needs must. The devil drives indeed. In group work lies the deepening of thought. In group work lie ideas, cross-lights, dispute and practice in dispute, cooperative thinking and practice in consultation, spur for the weary, pleasure for the strong. A threefold cord is not quickly broken. In group work lies salvation. All of this becomes fairly obvious if you but glance at some of the things which go to make up the practice of the law. The trial of cases. Your curriculum affords some background here. First-year procedure, second-year procedure, evidence. But what does it say on getting the facts out of your client, those inconvenient facts on which he keeps an inconvenient thumb? What does it say of what to do when on the witness stand, on cross-examination, he blasts your case with facts you had not heard of? What does it say of weighing evidence for its effect upon a jury? Or of the art of summing up? Or even of the initial analysis of a case, before trial, not for its law, but for whether it can persuade the tribunal? Some first conception your curriculum gives you of the ways and means of bringing on your cases. Some first conception of the task of making your record proof against reversal, or of attacking the other fellow's record. The rest is a question, in first instance, of going into court, of watching men at work, of putting yourself their problems and working at your own solutions, of gleaning their methods and seeing how far they help you think your way in, or take appellate practice. Most of your cases are appellate cases. But do you know how to build a brief? Do you see a record? Do you get practice in going through the record to size up what case can be best made on an appeal, or, equally instructive, to size up how the erring counsel below should, on the trial, have steered his course to bar out the objection you are making? Granted this first most vital operation, your moot court gives you some practice in the rest. Your moot court, not your courses. Or take the phase of business counseling. Some training, thanks to the new ferment in legal education, you do acquire in seeing the business bearing of the rules. Some training, even in sizing up a situation from all its legal angles. But how much training in sizing the same situation up according to your client's needs? How much in the art of negotiating with the other party or his counsel? Negotiating. When to insist on all the strength of your case, and when to yield, how much to concede. When it is better to lay out the cards, when it is better to add to your claim a dozen points you are content to let the other fellow win, in order to force him finally, as his one concession, to let you have the only point you want. The value of being alone in your own negotiating, but dealing with a number of the others, playing each one into discussion, and sweetly assuming the most favorable position any of them takes to be the standpoint of them all. And so on down. What tells you of your dangers with your client? That he will ask advice upon a partial state of facts, that if you give it to him, he will act, that if the thing goes wrong, he will regard you as responsible, and that you are, because as a lawyer you should know enough to suspect more facts, to suspect what they are, to get them out, whether he wants to bring them out or not. Who tells you that a corporation client means half the time one of the officers consulting you, not for advice, but to have someone to whom the buck will pass if his own judgment misses? Who tells you that a cautious lawyer never gives advice upon a situation in the loose, but carefully rehearses in his opinion the facts given to him fully, and gives advice expressly and only upon that state of facts? Or there is drafting. Most of you have not learned to write lay English. You cannot frame a clean-cut argument for beer and ale, or one against them. You cannot do a decent narrative, much less a quick, incisive piece of exposition. There is one way to cure this, and that is practice. But you do not practice, and even if it were cured, there would remain the task of legal composition. Drafting. I know no art more difficult. I know no art more fascinating. The law is given. We will presuppose you understand it. The situation, too, is given. We will presuppose you understand that, too. Not only what your client wants, but what he can get. Now, with these things in mind, to turn them into action, to find them words, to make the words clean-cut, precise in outline, to steer the words around the legal dangers, to keep them self-consistent as between the first paragraph and the fourth, to read them with an eye not only to where you want to get, but keenly from opposing counsel's outlook, with an eye to what they will seem to have said if 15 unanticipated troubles happen to arise. This, gentlemen, is drafting. I commend it to you. As yet, the proper slogan still is Tekel. I have said nothing as to that other hugely growing phase of practice, the work not with courts, but with the tax officials, the building commissioner, the workmen's compensation people, the legislative committees, and the rest. I have said nothing of office management. I have said nothing of a host of other phases of the practice. One thing, however, I must touch upon. The schooling of your hunching power as to the outcome of a case, as to the way a court will jump. If I am right in what I have argued, as to the uncertainty of the law in any one detail, if I am right about the leeway open to the court on facts and precedent, if I am right about the huge importance of court attitude, then hunching must be vital to your practice. Your client pays you to hunch right. Of course, he pays you too, if you hunch wrong, once. Now this hunching is not a matter of mere guesswork. Hall Johnson off the street. His hunch is worthless. Good hunching power is a resultant of good sense, imagination, and much knowledge. The more knowledge of what courts have done, the more skillful the hunch. The better quality the knowledge has, the more open-eyed the reading of the cases, the more skillful will be the hunch, so that your case work here builds a foundation in another way for all your practice. Only this, that the foundation from the classes is not broad enough. You need more cases, more and more and more. It is not so important that you remember their details, their holdings, where they can be found again. What is important is their constant, careful reading, seeing and following and understanding courts' reactions over and over again. As you get the facts in the case, hunch first, before you meet the outcome. Then go back over. If you were right, were your bases those the court displays? If you were wrong, wherein did you go wrong? The bad with the good you want, the blind with the keen, the stupid with the wise. For you will have to hunch as to all kinds of judges. Now in the main your casebooks give you better cases rather than worse. For a fair sampling you must turn to the advance sheets. Moreover, in the main your casebooks give you doubtful cases rather than the better settled. Again, for perspective you must turn to the current grist of the advance sheets. And I say once more, it does not make so very much difference whether you remember the specific rules. Good if you do. But even if you do not, there remains a deposit, formless, curious, but one which informs your hunches in the future. Authorities can in the main be found. An outcome that will go, a theory that will carry, these are the goal. I am left with the question of your staying in the school. There is the matter of handling your cases, of briefing, of review. On these I have said enough, except perhaps this word. Eyes are saved, and time is saved on review, if appropriate passages in your notes are duly underscored in bright red ink. But examinations call for some remark. We have two kinds. The essay type is made up of problems. A did this and B did that and C absconded, and whose is the donut? The first problem with a problem is to read it. The wise man reads it chronologically, taking the facts one by one as they occurred, and getting clear the bearing of each one as it occurred. He then has only one new, changing fact to wrestle with at once. He has then, by the time he has finished reading, analyzed the case. He may, if he finds it complicated, have made scratch notes to prevent forgetting, and have put into them the points of law he intends to make. When he turns to his answer, he is supposed to build an argument. An argument, as I have already suggested, begins with a conclusion. If you do not know where you are going, it is damnably hard to get there. It is even harder for the instructor to see how you got there. If there is no end, there is no beginning, and there certainly is no middle. I insist upon this. I insist upon it because students so regularly cut into the matter wrong end too. They come in nervous. They read the whole problem at once, like a commuter eating breakfast. They are left with so many conflicting impressions that they are even more nervous than before. They chew a half-inch off their fountain pens while the impressions swirl. A sudden glance at the watch shows that the time is already half gone. They dash into a discussion, write half a page, get a new idea between the eyes, reverse their position, acquire a further doubt, and close their answer with unfinished, pressed for time. But if you know where you are going, you can get there. What time is left can be devoted to tidying up. You have a chance, in essay questions, to wander curiously around the problem, indicating all the things that would have been if things were other than they are. Do that if you have time. But do the other first. One last point. If the case calls for a succession of decisions on fact or law, make each one as you come to it, and make it explicit that you have determined a doubt, and how you have determined it. And if your way of determining the doubt removes all further difficulty, say so. But do not stop. Your instructor wants those other difficulties discussed, which you have so successfully removed, so you go on. If, on the other hand, this doubt is resolved the other way, then essay questions, in a word, are built to test your skill at analysis, judgment, and argument. Also your judgment as to policy where rules conflict. But they are also intended to look into your knowledge of the subject. The rest, as teachers go, is useless without this. But this is never enough without the rest. Some information we require, even in case classes. Put it down first. Then you build on it, and with it. Another type of examination is the true-false. What that consists of is a large number of statements to be marked either true or false. Its great value lies in the amount of ground that can be covered in a relatively short time. First, by directing your attention to specific points, and second, by saving you the physical work of writing. You are not to regard the true-false examination as a mere exercise in memory, nor as merely testing information. It is possible to frame questions and series of questions, which test your powers of synthesis in a way which is difficult on essay questions. And it is possible to put a set of facts, and then frame true-false questions about that set of facts, which tests your powers of analysis almost as well as an essay question can. But the true-false or multiple-choice question does not normally test your powers of constructing an argument. And for that reason we supplement it somewhat regularly by the essay. Now, true-false questions can be tricky things. To begin with, there is always some unmentioned standard of truth or falsity. It is commonly safe to pick your instructor and his attitude as the standard. And one of the jobs of taking a course consists in sizing up what your instructor wants on an examination. On an essay question, this is advisable. Some instructors like to be flattered with their own ideas. Some prefer contradiction. Some insist that the dope which you bring into play shall be the precise dope which they most approve. Some have no such preference. Some are highly interested in policy argument. Though even these, I repeat, insist upon your stating the holdings of the cases before you indulge in flights of policy. Whereas some are interested almost exclusively in the outcome, as indicated by the cases, some expect from you only the material of the course. Some, on the other hand, undertake to examine on the subject as a whole, irrespective of how much of it has been covered in the course. Such are the stripes and spots of the instructor which need your attention, and diagnosing the instructor is as important, even in the essay, as diagnosing a judge will later be. But in the true-false examination, these things become vital, become matters of continued existence in the school, and you must operate accordingly. As to the bar examinations, which we do not control, I have little to say. They do play a part in our curriculum. The part they play is this. Since we know that you will, during the third year and immediately after, be reading with an eye on the bar examinations, be widening out your information, and deepening knowledge of law in a particular state, We have thus far felt we can afford to count on these examinations to accomplish this aspect of your education. Our hand is freer to work toward giving you techniques that you may need, instead of dope. As to the bar examinations themselves, I think we can be sure that any man who does the work of the school and survives in it has skill enough to pass them. What more he needs is information as to the statutes, as to the procedure, and as to the cases of the state concerned. And for these, as I remarked before, there is the library. But there remain, before we have placed the curriculum in its relation to the practice, some observations as to the arrangement of the work in the 3 years. The first year, I have already stated, aims to drill into you the more essential techniques of handling cases. It lays a foundation simultaneously for law school and law practice. It aims, in the old phrase, to get you to thinking like a lawyer. The hardest job of the first year is to lop off your common sense, to knock your ethics into temporary anesthesia, your view of social policy, your sense of justice, to knock these out of you along with woozy thinking, along with ideas all fuzzed along their edges. You are to acquire ability to think precisely, to analyze coldly, to work within a body of materials that is given to see and see only and manipulate the machinery of the law. It is not easy thus to turn human beings into lawyers. Neither is it safe. For a mere legal machine is a social danger. Indeed, a mere legal machine is not even a good lawyer. It lacks insight and judgment. It lacks the power to draw into hunching that body of intangibles that lie in social experience. Nonetheless, it is an almost impossible process to achieve the technique without sacrificing some humanity first. Hence, as rapidly as we may, we shall first cut under all attributes of Homo. Though the sapiens we shall then duly endeavor to develop will, we hope, regain the Homo. The most immediately essential part of the first year work is that in procedure, because it alone provides an adequate wherewithal to work out the procedural aspects of the narrow issue of all the cases in all the courses. The subject matter of contracts is supposed to be the general theory of the law of agreement, and to build a foundation for a body of other materials you meet later, such as sales, insurance, partnership, mortgages, etc. The torts course has its importance less as a foundation for specific materials than as a cleaning up of the ground outside of the field of transactions, a cleaning up of it early, so that the transaction side of law may not wholly obscure the picture in the future. Development of legal institutions, as well as some parts of torts and some parts of procedure, are all intended to open up a most important phenomenon in law. The conditioning of legal growth and legal action, not merely by the specific precedents of the immediate past, but by the whole course of legal history. These historical aspects will seem to you in good part strange and dead and useless. But however strange, they are neither dead nor useless. They are not dead because their hand controls present developments. They are not useless because through them, and through them only, can you understand what the present developments are, how present developments hang together, why they are not more efficient and adequate tools of society than they are. It is not enough to study legal institutions as they stand. I have already referred to the snobbery of existing institutions. Nowhere is it more striking than in the law. Nowhere either are there more thin-blooded parasitic signs of past peers among the snobs. Piece after piece of law stands as a survival which is valueless or worse, and still goes on unchallenged. Piece after piece which has some value has its value as an old-fashioned bucket will have value in a neighborhood where every other outfit is using an electric pump. Now to study these law things in their present shape, and only in their present shape, is almost inevitably to come to take them for granted, as curious, but as present, as things which are, and which merely because they are require no criticism. Perspective comes only through the perception of difference. To perceive differences must be presented. To see such survivals set in the time which they fitted and out of which they arose is to gain insight, not only as to what they are, but as to how much they are worth today. We cannot hope to achieve this as to every legal institution. There is not time. But the point of view can be developed, and can be brought to bear upon enough concrete material to drive it home, and to be worthwhile, as to that concrete material in itself. Your history will have, too, another bearing. As in geology, the forces that changed the past are at work today. Case law changes from year to year. But when you read modern cases, almost inevitably you lose the sense of change and the perception of the ways of change over the job of fitting holdings together. Unless, that is, sweeping through long stretches, you have become alive, awake, sensitive to change and its ways and its meaning. In the second half of the first year, you get your first dose of the law of property. By that time you have come to see contracts, the law of commercial transactions, as a thing depending very largely upon the shaping of the parties. The law of torts you have seen as a field in constant flux, as the affairs of men produce one clash and then another. Procedure, which appears at first fairly rigid, has come to seem the lawyer's special ritual. Then you meet property, and you discover that there is a whole body of law in which the molds are cast with a firmness torts and contracts never dreamed of. This is of peculiar value when later you meet such bodies of law as leases and mortgages, and expect, at first blush, to see them handled like business transactions, only to discover that they are compounded, not only of commercial law and concepts, but of the property point of view as well. The procedure work, meanwhile, goes on, and takes you into that more elastic field of procedure and law that we call equity, the body of law that grew up in the chancery courts, outside of and beyond the common law of that time, which had succumbed to the eternal tendency of institutions to grow too rigid for their changing purposes. Or better, for their purposes amid changing conditions. Here again you meet a new point of view, which informs great bodies of the law you will later have to meet. Reformation of instruments, trusts, redemption of mortgage, injunctive relief, and the specific performance of contracts for the sale of land. You meet further in the second half of the first year, and for the first time, a systematic approach not to the cases, but to legislation. Until then, legislation has been looming in the background somewhat ghost-like, more guessed at than even glimpsed. It has become high time to bring it forward as one of the vital processes of law today, as the device which, by one sweep, can accomplish more than 50 cases. Finally, you meet the criminal law. I have already indicated that this is not for most of you a course in any way related to your bread and butter. It is the first entry on the scene of what I shall call mind-opening, or background or cultural, courses in your professional training. It is put into the first year because at least this piece of background is deemed essential to your appreciation of the law's place in the community. When you come to the second year, you enter into a regime of electives. Meanwhile, the fundamental tools, the most fundamental background, these have been provided. What you know will, of course, need practice, and more practice still. Both range and skill will badly need development. Yet the most basic stuff you will have met. Still, the case method has passed its peak return per hour. Your common sense has gone. It is time now to seek to regain it, to reshape it. It is time, too, to bring your ethics out from under ether. This time, however, in a better guise, a common sense, a body of ethics, no longer at war with law or preventing you from seeing the legal question, but informing law, helping you solve and criticize. No longer impeding your techniques, but furthering them. This, I think, best achieved by turning forthwith to one or more of the background courses. Family law, in which you see law wrestling with well-nigh the oldest of our institutions, as that institution itself changes and shifts in response to the growth of cities and the break-up tendencies among the older social groupings. Industrial relations, in which you see law in the first instance, stamping out all moves for social change, and then, more gradually, helping them along. Constitutional law, the apex of so-called judicial government, in which you find 9 judges in Washington giving their final voice as to how far the legislature may or may not revamp the machinery of American society. Comparative law, or Roman law, in which a challenge to re-examination of our own institutions is presented more vigorously, if possible even than by history. Or the work you have done in statutes is picked up and merged with casework in bills and notes or sales, where a whole field of law has been brought into a code, and the code lies before you to be construed word by word, and section by section, and as a whole. intensively construed, and your construction checked against the cases over a whole half year. And the work in procedure is picked up and carried down to date through the more intricate proceedings in our modern courts. Or the commercial side is picked up and carried on in the course in business organization, which sets the picture of the modern business unit, or in creditors' rights, the law of debt collection, or in security. Two things are clear as you move through the second year. One is that your range of choice extends beyond what you can do in courses. The other is that the time has come and come with a vengeance for independent work outside of class. I add a last. Graduation already impends, and the time is passing when you have a chance to take work that has some chance of opening out your minds. The second year is a good time to use such chances as are open there. There begins too in the second year a regime of papers, the production of your own research, in the course of which you must make some acquaintance with the library and with the art of writing. What has been said of the second year must do as well for the third. There is then only one new problem there, and it should not be new. The problem of preparing for the bars. Any man with an atom of intelligence begins that as soon as he has first learned how to handle cases. That is so obvious that it does not need repeating. There are, however, three things more that I should mention. First, in addition to what I have said of choosing courses, the question of instructors. You will find some you like and some you don't. You will find some whose vaudevillian arts bring the stuff to you with little effort on your part to keep awake, and others who put on no song and dance. The thing that is vital to remember in all this is that technique in keeping a class awake is no indicium of brains or of deep thinking, and even more, that the absence of such technique is no indicium of the absence of the brains. There is no man on the faculty who has not much you need to learn. But the most adventitious of his qualities is his skill in putting on a show. If you have an eye out to your own education, you will indeed distrust the man whose class proves too enjoyable. He may be sound. Indeed he is, or we would never let him get before you. But what you will get out of him need not be sound. The more pleasing his performance, the more the enjoyment of the performance, between your ears, will substitute for thought. Your chance of education, I repeat, is vastly greater with the performer whom the cheaper-minded would think wet. To milk his classes, you must keep yourselves awake. To keep yourselves awake well, you must milk his classes. Have you ever considered the cost to you of these so-called effective teachers, the cost in the dulling of your own initiative, and in the loss of fruits from other classes? Another aspect of this faculty business is that there is no one of us who is not good. And at the same time, there is no one of us who is not bad. We are lopsided, each of us. And our teaching is even more lopsided than ourselves. Partly this is the way we grow. Partly it is deliberate. We feel it well that you should be exposed to a series of lopsided men, to the end that you learn from each his virtues and see in each his defects. For you the balance, for you the rounding out, for you the building of a legal equipment better than that of any one of us. Now this you jeopardize if you play favorites strongly. You jeopardize the very balance which the faculty has put years in trying to achieve, both by placing all instructors in courses that give opportunities to their peculiar qualities, and by picking out instructors with most peculiar qualities to place. The second matter is that of informal instruction. If there be those among you who do well, and who desire to get loose from classroom work, to throw themselves into more intensive work in smaller groups, the opportunity is open in the second year and after. What I think upon the wisdom of seizing that opportunity should need no further statement. Third, there is the matter of the law review. We have in law schools an aristocracy of a peculiar kind. We may almost say it is a perfect aristocracy. One achieves membership exclusively in terms of his performance. Membership carries honor, but the honor that it carries is the duty to work and slave and drive oneself as no other student is expected to. A perfect aristocracy, then, because continued membership is based on higher performance than is demanded of non-members. Now this law review is a scientific publication, on which in good part the reputation of the school depends. Here is a thing American. Here is a thing Americans may well be proud of. There is not, so far as I know in the world, an academic faculty which pins its reputation before the public upon the work of undergraduate students. There is none, that is, except in the American Law Reviews. Such an institution, it is a privilege to serve. Such an institution, it is an honor to belong to. And by virtue of the terms of tenure of office, of this you may be sure, to earn that honor is to earn an education. I hold out before you, then, as the goal of highest achievement in your first year, this chance to enter on real training in your second. Here then we are. 2 men's work, for 6 years at double time, might turn any one of you out equipped to do quite well. The medics take 6 years, for 1 man at single time, and feel the public to be poorly served. I have not seen that their task is in any way more difficult than yours. It seems to be simply that the public's pocket is to the public less precious than its health. So, gentlemen, the prospect. The thicket of thorns. The subtleties of the case method to disentangle, and a half-year course and procedure to master before you can bring to disentangle them. Yet you are to begin the disentanglement forthwith. Logic across your path, and history, and the social bearings of the rules, Hofeld's analysis, and clashing schools of jurisprudence. Details, unnumbered, shifting, sharp, disordered, unchartable, jagged. And all of this that goes on in class, but an excuse to start you on a wilderness of other matters that you need. The thicket presses in. The great hooked spikes rip clothes and hide in eyes. High sun, no path, no light, thirst, and the thorns. I fear there is no cure. No cure for law, but more law. No vision save at the cost of plunging deeper. But men do say that if you stand these 1,000 vicious gaffs, if you fight through to the next bush, the gashing there brings sight. The other one.